Today, the U.S. Supreme Court struck down affirmative action in college admissions. The conservative majority calling the use of race a violation of the Constitution's equal protection guarantee. The liberal minority calling the decision a tragedy for all of us. Our Washington Bureau Chief Alex Cameron has more from the Supreme Court tonight.
This is not the first time this issue has come before the court. Previous rulings have allowed racial screening to continue, mindful of universities' legitimate interest in achieving racial diversity in their student bodies, but also noting that the practice could not continue indefinitely. And in a 6-3 ruling, the conservative justices said that Harvard, the University of North Carolina, and other schools using race in their admissions processes had exceeded the narrow scope of allowed exceptions to the 14th Amendment's Equal Protection Clause. Chief Justice John Roberts writing, "Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice." Small advocacy groups came out to protest the decision, and President Biden also weighed in.
Today, the court once again walked away from decades of precedent, and I strongly disagree with the court's decision.
Writing in dissent, Justice Ketanji Brown Jackson said the majority is oblivious to reality. Today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. Oklahoma banned the use of race in college admissions a decade ago, and its congressional delegation stands solidly behind today's decision. "Glad to see the U.S. Supreme Court strike down affirmative action as unconstitutional," said Markwayne Mullin. "College admissions must be decided on equal standards of merit and achievement, not race-based preferences." Now, the end of June typically marks the end of the term for the Supreme Court, but there are still several cases outstanding, including the student debt forgiveness case. So I'll be watching for that opinion after the holiday next week. At the U.S. Supreme Court, I'm Oklahoma's own Alex Cameron.